Welcome to Law for Life with Georgia.
Welcome to Law for Life with Georgia, where attorney Georgia Konstantakis brings nearly 3 decades of Wisconsin legal experience to help her community stay informed, protected, and prepared for whatever life brings. I'm Shamika Rhymes, and today Georgia's going to explain how to navigate Wisconsin's marijuana OWI charges. Welcome, Georgia.
Oh, thanks for having me, Shanika.
Thanks for taking the time out to talk about this topic. So how is it possible for a driver to be convicted of an OWI even if they are completely sober at the time of the stop?
Well, that's kind of impossible. People may appear sober, but we have the term, it's called functioning alcoholic. It's someone who can literally function and do anything necessary, including driving, but still be over the influence of intoxicants. So in Wisconsin, we have we have certain restrictions, certain laws. In this state at this point, driving under a controlled substance is considered illegal, period. It is not accepted. There is no threshold. There's nothing. If you're driving with any type of weed in your system, it's called Delta 8 or Delta 9, anything detectable of that nature, then that is considered a restricted substance, and you will be charged with an OWI or an operating. It's called an operating with a controlled substance versus operating while intoxicated. So we have two different terms. And again, in Wisconsin, you can be impaired if there's any detectable amount of restricted controlled substance in your bloodstream. That's it. You will be charged. Also with OWI, if it's over a 0.08, that is what we have here in the state of Wisconsin. If you are driving with a restricted BAC, we call it, blood alcohol concentration of over a 0.08, then you are driving under the influence. So yes, you can be found guilty in that instance.
How do you defend a client who used marijuana legally in another state days ago, but is now facing a life-altering conviction in Wisconsin?
Yeah, that happens all the time. I have clients who'll say, yeah, I got stopped in Wisconsin, but I had done the drugs the day before. There were still detectable amounts in my bloodstream. Unfortunately, if you do have any detectable THC in your bloodstream, you're going to get a ticket in Wisconsin, regardless. Again, in this state, it is illegal, completely 100% illegal. It doesn't matter that you consumed it in, say, for example, Illinois, where marijuana is legal within a certain threshold. That is not the case in this state. So be careful when you're crossing state lines. I say to people all the time, don't come to Wisconsin if you've got any type of THC in your system. So, and there are tests that can detect that, whether, most times it's a blood test to determine whether in fact there is THC in your system. And unfortunately, it smells. So most times a cop is going to use their primary sensors and just say, hey, I smell weed. Were you smoking? That's going to be a question that they'll ask at the time of the stop. And 9 times out of 10, the defendant's nervous and they're going to answer the question, yes, I did smoke, but I smoked in Illinois. Ha ha ha, you can't catch me. Well, guess what? They can catch you. As soon as you cross that line, you are going to be operating with a controlled substance. You will have that citation if they in fact find THC, any traceable amount of THC in your system.
Well, like you mentioned earlier, that alcohol, the limit is famously like 0.08, but is there any safe threshold for THC in Wisconsin, or is it literally any detectable trace enough for a prosecutor to secure a conviction?
It's called zero tolerance for any active THC. If they see any THC, any traceable amount of THC in your system, they can charge you. Unfortunately, that's how it works. Wisconsin doesn't have a defined legal limit for THC. Not yet. Not in this state. Again, in other states, such as Illinois, yes, you can have a certain amount of THC in your system and not get charged. But not in Wisconsin. It's zero tolerance. Zero. So
Thank you.
that's how it works, unfortunately.
Yeah. Well, in a suspected marijuana OWI, what specific clues is an officer looking for during a roadside stop to justify a mandatory blood draw?
Yeah, well, like I mentioned earlier, the biggest is the odor. It's like the episode of Cheech and Chong. You just smoked a bowl and all the windows are fogged up. Odor is huge. So the other one is glassy, red eyes, usually just slow speech, kind of, you're just really up in the clouds, hey, or maybe a delayed response, confusion. Those are kind of the key points. The other one, like I said, if a cop comes up to you and they say, hey, you've been smoking, because obviously the car smells like it. And if you admit it, that is an admission. So that right there, they can grab you for it. There are certain tests, sobriety tests, that they're called field sobriety tests that individuals have to pass. And if you've been smoking, let me tell you, you are going to perform poorly on those tests. They really are pretty accurate. They make you do the walk and turn test. There's a series of them. Touch your nose, say the ABCs backwards. I mean, true story, I probably couldn't even do the ABCs backwards,
either.
even sober. But these are things that they ask you.
Me either.
The other big one is if they see any type of remnants in the vehicle, like paraphernalia of some sort, or, I mean, heck, even a lighter, could start. And in the state of Wisconsin, it's no longer probable cause. It's reasonable suspicion to believe. That is a lot less of a threshold to start asking those kinds of questions and then start the procedure of field sobrieties and then doing the drug test. So it's reasonable suspicion to believe that the person is in fact doing weed or drinking under the influence. So it's getting harder and harder. These cases are really, it's just getting harder and harder to defend them because the cops are just getting so good at it. And the other thing is they're putting dash cams now in the cars, as well as they'll have a camera on their person. So that's something that, police officers are starting to do more and more just to even protect themselves from, any malfeasance of any kind. So
Right.
that is something that's happening.
So I'm just thinking about, with the excuse of, oh yeah, I smoked in Illinois, yesterday,
Yeah.
but some people that smoke a lot every day, the odor,
Oh.
it's in their clothes and on their
At
skin.
least 30 days. 30
Okay.
days it's in your bloodstream. You
Okay.
cannot get rid of that. The active, though, THC may not be,
Mhm.
but it's in there. It's in there. You can't escape it. Let's just put it that way. And the other thing that they do now, when they're conducting a traffic stop in Wisconsin, they'll have 2 patrol cars. There's the first one that does the active stop, and then there might be another one. If there's a suspicion of drugs, they'll call in the dog. So the dog will come around, sniff the vehicle, make sure, there isn't anything illegal happening.
Mhm.
Sometimes when they do a stop and it's just a simple traffic stop for speeding, and then from there it escalates. And then from there they find out, oh, this person was smoking weed. Oh, by the way, there's also, an AK in the back, or there's a handgun or something like that. It just can really escalate very quickly.
Mhm.
So, unfortunately, you gotta just obey the rules.
What would you say are the most common science-based defenses that you use to challenge the integrity of a blood sample in court?
The big one is chain of custody. Was the sample handled correctly? Was it labeled? Was it stored properly? Contamination or, improper storage of whatever it might be. We look at temperature, preservatives, that kind of stuff. Another thing that, there's different types of testing methods to make that determination, but 9 times out of 10, you're going to a hospital and they're doing everything to the letter. Unfortunately, it's hard to make that defense of contamination of the specimen. The other thing that we look at is calibration. If there are any errors in the way that maybe the equipment that they used to determine what your alcohol level was, maybe it was defective in some way. They didn't calibrate the machine. And those need, they have lab errors. So that stuff happens. And then the other thing is timing issues. We usually have the magic hour is 3 hours. We make defense and arguments based on from the time of the stop to, executing and all the way to the end. If the time frame is long, we have a better argument and we can use the bell curve to make a determination and say, well, at the time of the stop, when you did this, his blood alcohol level was probably under a 0.08, but obviously when you took him in 2 hours later, it was elevated a little higher. So we can play games with that kind of stuff as well.
Well, how does specialized training of drug reinforcement agents impact a marijuana OWI case? And can their subjective observations be successfully cross-examined?
Drug experts, I'm a city of Franklin municipal judge, and we have cops who are experts, they're DRE experts, and they know their stuff. That kind of testimony is very difficult to cross-examine because they know what they're doing, they know how to handle the items, but there is the occasional person who doesn't have experience. And that's where we kind of can, step in and try to cross-examine them and make kind of the argument that their observations were not exactly, what they seem to think. And I can't tell you how many times we look at an incident report and we see the exact same story. There's nothing different in the report. In that incident report, it's exactly the same verbatim for all these traffic stops. Red glassy eyes, odor of intoxicants. They just hit every single one of them. And granted, most times that is the case, but you do have that occasional case where there's inconsistencies in the report. So, and there may be limited training. They may not have done the field sobriety test the way that they should have, based on and using the bell curve and the timing. Sometimes they blow it. They go past the 3 hours and we're like, beautiful. Let's get this reduced or dismissed. So, in short, it's really hard to challenge. It's hard to challenge someone who knows what they're doing.
Well, with the federal loophole for hemp-derived products set to close in November 2026, how will the recriminalization of Delta-8 and THC-infused drinks change the way Wisconsin police handle these OWI stops?
Again, in this state, it is completely illegal. So police may use the THC-related impairment. They may do some maybe uniform type of a law where they say, okay, and this is where they could change the law, where they say, all right, now you can have this much of Delta-8 in your system or Delta-9 in your system. It could, in fact, become a universal law where, hey, we can't charge this now. But in Wisconsin, it's not the case. Right now, Wisconsin hasn't changed it. So there's really no effect. Any traceable amount of THC in your system, it is completely illegal, period. And it just doesn't matter in Wisconsin. Doesn't matter. Even though it was hemp derived, it can honestly show up as THC in your system. And that's what's happening now. You see these people selling, these vape pens and so forth at gas stations. And, they're just trying to make a buck and they're telling you it's hemp. It's not THC. Well, sorry, it is. And you just sold me a bunch of BS. And now I'm being charged with this. Kids definitely are very impressionable. And we're seeing more and more children with vape pens in the classroom. And that is a shame because truly and honestly, I mean, if you look at these, they're getting smarter and smarter. They look like it could be just a flash drive, which is it's just crazy the way that they're making them.
Mm-hmm. Yeah, some look like candy bars. You wouldn't have a
Yeah.
clue. And then they don't also realize that the
No
health
clue.
impacts that they're causing.
No clue. In fact, I got a funny story. So we had gone to a drug seminar, and Amazon now is selling, listen to this, they've got these underwear, and in the underwear, they put, excuse me for saying this, but they put a poop stain so that the cop or the person that's, testing you or looking for drugs can't find the drugs. And it's buried in the underwear.
Oh, wow.
In between the underwear, the lining, and then the poop stain. So you can only imagine how far these kids are going.
Right.
Another big thing that we're seeing is they're taking a Coke can and cutting out the top, and then inside they're putting the drugs inside the Coke can, so it doesn't look like they've got anything but a soda.
Wow.
So yeah, it's incredible.
Yeah.
What they're doing these days to hide any type of drugs or alcohol.
Getting creative. Goodness.
Very creative. Very creative.
Well, does a medical marijuana card from Wisconsin or another state count as a valid defense?
You know what? No.
We're not getting around any of it.
THC is THC. I'm sorry. There's no. Oh, Lord. But yeah, no. So next question.
Well, to wrap up, what happens if a driver refuses a blood test in Wisconsin when being investigated for a marijuana OWI? Will their license be automatically revoked for a year, regardless of whether or not they were actually impaired?
Yeah, there is, it's called refusal to take any chemical test. And in Wisconsin, we have the implied consent law. So if you're driving on that roadway, that's a privilege. So because it's a privilege, you've implied to consent to any laws that have been enacted. And in this case, you're implying that you will take a blood test if the police officer asks you. So if you don't do that, it's a 1-year revocation refusal. I mean, the penalties are steep. And you have to install the IID device in your car for a year because you did refuse. That's why it's super important. Anytime you do get a refusal, there's 10 days. You got 10 days to actually contest it and ask for a hearing.
Okay.
So don't waive your rights. I always say, hire our law firm to take care of it immediately. Don't think you're going to evade the law and it's just going to go away on its own. It's not. So get on it immediately and take care of it. So,
well, Georgia, this has been so informative, especially learning about all the creative things that are out there now. So I want to thank you for going through this with us today.
You're welcome.
And it's been entertaining too. That's it for today's episode of Law for Life with Georgia. To learn more about attorney Georgia Konstantakis and Konstantakis Law Office, LLC, visit konstantakislaw.com. Thanks for listening, and be sure to subscribe, share, and leave a review if you found this episode helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.